Thanks, ma'am. 30 seconds.
Okay, okay. Yes.
We are on YouTube.
Yes, I think we can begin the session. Yes.
Good morning, everyone. Honorable Senior Advocate Sri Rajiv Ranjan Sir, the Advocate General of State of Jharkhand, our Chief Guest for said event, our special guest, Honorable Senior Advocate Sri Rajendra Umap Sir, Vice Chairman of Bar Council of Maharashtra and Goa, Honorable Dr. Ujjwala Bendale Madam, Dean and In Charge Principal of Bharati Vidyapeeth deemed to be University, Pune New Law College, respected faculty members, friends from the student community, and all those joining us through the digital space. We, on behalf of the Bharati Vidyapeeth deemed to be University, Pune, the New Law College Environment Cell, welcome you to a very special edition of our webinar series on the topic Interplay between Constitution and Environmental Sciences. Before we proceed, may I kindly request our dynamic and visionary in charge principal, Dr. Ujjwala Bendale Madam, to kindly address this gathering.
Thank you, Yash, and good morning, everyone. Welcome to this webinar on interplay between Constitution and Environmental Sciences, organized by Bharati Vidyapeeth, deemed to be University New Law College, Pune, Environmental Cell, in collaboration with Bar Council of Maharashtra and Goa, coordinated by Dr. Jayashree Khandare and students team, and headed by Dr. Jyoti Dhar, Madam. Dear all, we know that this year Sweden is hosting this event on World Environmental Day 2022. The theme of this event is Only One Earth, focus on world's togetherness in the direction of creating the atmosphere conducive for peace, harmony, and prosperity by saving the nature and life. The policy theme is to create and adopt a lifestyle which should be pollution-free green land. And the main motto is to protect the mother nature. So, dear all, to enlighten us, we are blessed by an eminent personality of law fraternity, Honorable Advocate Rajiv Ranjan Sir, Senior Advocate, Advocate General of Jharkhand. Welcome, sir. I am grateful to you, sir, for sparing your time today for celebrating this World Environmental Day with us online. I also wholeheartedly welcome Honorable Advocate Rajendra Umap Sir, Vice Chairman, Bar Council of Maharashtra and Goa, who has always supported the college activities cell and promoted the law students to become best practicing advocates. I am here today, sir, to formally introduce you to Bharati Vidyapeeth, deemed to be University and New Law College. The institutions of Bharati Vidyapeeth were accorded deemed university status in the year 1996 for its academic excellence. Bharati Vidyapeeth is accredited with A plus grade in 2017 by NAC. It has category 1 university status by UGC and is ranked 63rd by NIRF. Bharati Vidyapeeth, deemed to be university, has established its academic excellence and offers programs in innovative and emerging areas. Presently, it has 29 constituent institutions, including 3 research institutes, which are exclusively dedicated to research. Bharati Vidyapeeth is multi-campus and multidisciplinary and is catering to the needs of urban and rural students. It has world-class infrastructure and facilities. It has launched several innovative and academic programs. It has best teaching learning processes and has entered into national as well as international collaborations. So, all this has been possible only because of Honorable Dr. Patanrao Kadam Sahib, the founder of Bharati Vidyapeeth, deemed to be university, a visionary who, at the age of 20 years, decided to establish Bharati Vidyapeeth as a distinct education institution. Today, Dr. Patanrao Kadam Sahib is the guiding star for whole of Bharati Vidyapeeth fraternity. The zestful patron of Bharati Vidyapeeth is Professor Dr. Shivaji Rao Kadam sir, the Chancellor Bharati Vidyapeeth, deemed to be university, member UGC, member NAC. And we have very young and dynamic patron Bharati Vidyapeeth. He is Honorable Dr. Vishwajit Kadam sir, Pro Vice Chancellor Bharati Vidyapeeth, member AICTE, and Honorable State Minister for Social Justice and Special Assistance Department. Honorable Minister Dr. Vishwajit Kadam sir is an excellent visionary like Sahib and is stepping on the same path of success and is very positively carrying forward the torch of Bharati Vidyapeeth to more greater heights. Supporting Dr. Vishwajit Kadam sir is Dr. Asmita Tai Jagtap, Executive Director, Bharati Vidyapeeth Medical Foundation, Pune, Sangli, Navi Mumbai, a very brilliant administrator like Sahib. And supporting all of them is Professor Dr. Manik Rao Salunke sir, Vice Chancellor, Bharati Vidyapeeth, deemed to be university, a disciplinary and an excellent administrator. Sir, today under the excellent guidance of our beloved patrons, New Law College Bharati Vidyapeeth has been consistently ranked amongst top law institutes of India by Career 360, The Week, Lawyers Collective, India Today, Education Post, and so on. New Law College has been re-accredited with A+ grade by NAC and has also received Gold Star Award from Bar Council of India on the eve of its Golden Jubilee celebrations. This year, New Law College is awarded with Best Law College in India for Research and Pedagogy by IIRF Education Impact Awards, New Delhi. New Law College has always encouraged the students to take up the field of their interest and to train the students as per the requirements of the respective fields. The college has started different cells like the Madhyastata ADR cell, the Center for Artificial Intelligence, then CCDL, that is the Community Development through Law, and many other cells. And one of the important significant cell is Environmental Cell, which was established in the year 2019. The core aim of the cell is to carry out the activities in support of the Sustainable Development Goals as envisaged in the Agenda of Global Sustainable Development 2030. The Environmental Cell of our college has organized very significant sensitized programs, workshops, seminars, webinars, industrial visits, and community activities, by virtue of which it has earned significant name and fame in a very short time, and its research work and ground activities are highly appreciated by renowned environmentalists, member of parliaments, and senior advocates. Sir, with your blessings and guidance, New Law College will surely do commendable job in protecting the environment. Once again, I welcome you, sir, and I express my gratitude towards you for gracing us today. And with this request, I rest my speech over here. And the request to all my students and everyone is that on this World Environmental Day, let's stop harming the nature. Let's join hands to bring a positive change to make the planet Earth a much healthier, greener, and happy place to live. Thank you so much. Yeah, over to you, Yash.
Thank you very much, ma'am, for those enlightening words. Now, 5th of June in a calendar year holds special relevance for every individual on account of it being celebrated as the World Environment Day. It provides us with an opportunity to not just introspect upon the many ways in which development has impacted our environment, but equally reflect upon the many ways in which we can protect and restore its pristinity. For legal professionals, especially, it is a time to take pride for the efforts taken to ensure that a right to clean environment is interpreted as very much a part of the Constitution, guaranteed under the fundamental rights, and pledged to carry on with the same momentum in future as well. Ladies and gentlemen, it is to our honors that we are joined today by a towering figure in the field of advocacy who has committed his entire life for the cause of environmental justice and devised newer ways of understanding its jurisprudence. Honorable Senior Advocate Shri Rajiv Ranjan. Born in the year 1968, Sir is currently the Advocate General of State of Jharkhand. A polymath, Sir completed his schooling from DAV Jawahar Vidya Mandir, Ranchi, and went on to pursue his bachelor's in chemistry with honors from Delhi University. Their good selves completed their LLB degree from the Campus Law Center of the Delhi University in 1993. While taking up important and major assignments on behalf of the central government in the initial years of their career, Sir has the distinction of appearing in many important constitutional matters before the Jharkhand High Court, including the domicile matter. Well versed in the field of constitutional law, Sir has ably handled with distinction where other matters concerning labor law matters, company matters, service matters, and other miscellaneous civil and criminal cases. As the mark of a true leader, Sir has been instrumental in passing the Jharkhand Advocates Welfare Act 2012 with enhanced benefits for advocates. Various new initiatives and welfare activities have been initiated under his chairmanship. We are equally blessed to have the august company of Senior Advocate Rajendra Umap sir, who currently holds the office of Vice Chairman of Bar Council of Maharashtra and Goa. A distinguished advocate and an able leader, Sir has held numerous responsibilities of prominent organizations like Life Care Foundation, Vikas Pratishthan Chandan Nagar, Sant Tukaram Shikshan Sansthan. Sir, apart from others, Sir has also been the president of Pune District Bar Association in the year 2013 and 14. We welcome both of our honorable guests to this event. May I now request our chief guest, Senior Advocate Shri Rajiv Ranjan sir, to kindly address this gathering.
Thank you, Yash.
Rajiv sir, very good morning and welcome.
Very good morning, sir.
Yes.
Rajendra ji.
Yes, sir.
Glad to know that Bar Council of Maharashtra has been participating in this webinar.
Yes, sir.
Also the Vice Chairman.
Yes, sir. I have a meeting, so I was waiting for you, and just I will start meeting later on. But all the best wishes from Bar Council also.
Thank you, sir. Thank
Yes,
you,
sir.
Rajendra
Yes.
ji. Thank you
Yes.
so much.
Yes, sir. Thank you.
I have also met so many of your members, DCI members from Maharashtra.
Ji.
Many Bar Council of India meetings. I have been chairman of Jharkhand Bar Council.
Okay, sir. Sir, now Zaibhavi sir is there. Jain Zaibhavi sir.
Jain Jagal. Before that, I think
Yes.
One gentleman, I met him. He was a BCI for a very long time, for 10 years. Almost.
Yes, sir. Yes.
So it's nice to be. Nice to have you here in the webinar. And please come back after you finish your meeting.
Carry on, sir.
And please come back after you finish your meeting.
Yes, sir. Sure. Yes, sir. Thank you, sir.
Thank you. Thank you, Dr. Ujala, for enlightening, and a very nice introduction you have given. And a very good morning to Professor Dr. Shivaji Rao Kadam, who is Chancellor of Bharati Vidyapeeth, and Vice Chancellor Professor Dr. M.M. Salunke, Dr. Vishwajit Kadam, Pro-Vice Chancellor, Dr. Ujwala Bendale, the Dean and In-Charge Principal, Dr. Jayashri. A very good morning to all of you, and Advocate Rajendra ji, who has just left us and will be coming back in a while. And very heartening to note that you have organized a very good webinar on a very relevant topic for today, which is the environmental, in the light of environmental jurisprudence. For the topic has been worded as interplay between constitution and environmental sciences. So this is a very relevant and a very important and a very current topic. And today being a World Environment Day, so this has assumed even more significance for today's webinar. And it's very rightly chosen topic. So before I begin the discourse or discussion upon this interplay between the constitutional ethos and the jurisprudence on the environmental sciences, we all know that we belong to a very ancient civilization where we have worshipped the natural powers like Agni, Varun, Vayu, and our Prakriti. Right from our Rig Vedic period, all our slokas and our incantations to gods is the personification of natural powers like wind, forest, Agni, Surya, all Prakriti, the natural forces of the nature have been personified as gods, and we have been worshipping them. So we belong to a nation where we respect the natural powers, the natural forces, which together we can say that it is an environment for the planet Earth. So it is something which is not alien to our civilization. It is only going back to our roots. And if we say that this is a part of our virasat and our civilizational ethos, that we have to give respect to the environment, the forest, to the winds, to the rivers, to the natural resources around us, and to pay respect to them, even to the level of God, and to worship, so as to give them respect and preserve them, and be a part of the nature. The environmental laws, basically, an environmental jurisprudence was centered around Indian Forest Act of 1927, as we all know. I'll just give a brief outline of the legal framework that we have. Then we will go to the various aspects, because environmental laws have become a very, as you have rightly worded, environmental science. It's more of a science now. And the realization that the science, environmental science, if we ignore, then we are ignoring our very existence. Therefore, pre-colonial era, we only had a Forest Act 1927, which is largely and popularly known as a natural resources law. That Forest Act was mainly to define certain areas of natural resources mainly for its extraction and primary production of goods and services, and focuses on secondary processing, transportation, manufacturing, disposal, and more on the exploitation of the natural resources. So therefore, the Forest Act 1927 is still relevant, still is on the statute book. But as you know, the scenario began to change from the Stockholm Conference of 1972. After 1972, you would find a host of legislations on the environmental laws. By incorporating the principles that were discussed in the Stockholm Conference and the ethos, and that directly gave result to the Forest Conservation Act of 1972. Then, as you all know, the 42nd Amendment of the Constitution came, which incorporated and brought in Article 48A, which brought the environmental protection as a directive principles of state policy, that the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. Similarly, the same was incorporated in the fundamental duty also in the 42nd Amendment, Article 51A, small g. And all of the other host of legislations on environmental law, like Water Act of 1974, Air Act of 1980, 81, Wildlife Protection Act of 1972. All those acts were more or less enacted after the Stockholm Conference. And the specific legislations of Water Act and the Air Act was more designed to prevent the water pollution, and Air Act was to arrest the air pollution, or then the noise pollution was also added in 1988 to the air pollution. So these are the broad framework under which we were functioning from after the Stockholm Conference of the Air Act and the Water Act. Then the Forest Conservation Act came in 1980. And after that, a sling of judgments, because in the early 80s, as we all know, our apex court, that is our Honorable Supreme Court of India, stepped into many environmental issues, and it gave landmark judgments. I will come to them later on by classifying them into pre-Godavarman and post-Godavarman judgments. So that also was a trigger for enactment of many other laws, and the Basic Environmental Protection Act of 1986 was a major environmental protection law which came in 1986, which now governs the field because it gave immense power to the central government under Section 3 and to devise policies under Section 5. It can issue directions, it can issue policy guidelines, and it can frame rules. The Section 5 environmental protection rules also have been enacted by giving specific directions and policy directions and initiatives to the environmental protection. This environmental protection, therefore, also takes into account the specialized nature of environmental science and having expert body. And also it spoke for the first time environmental impact assessment, which we also have now at the central level. One EIA committee is there, and every state has a state environmental impact assessment committee, and at the district level, district environmental impact assessment committee. And only upon this environmental impact assessment, any environmental clearances are given. So Environmental Protection Act for the first time speaks about environmental clearances by depending upon environmental impact assessment of any project. Earlier, it was only limited to Air Act and the Water Act. But now, as you know, under the Air Act and the Water Act, the state pollution boards have been created to grant NOCs, and largely for the purposes of consent to establish an industry or a project, or a consent to operate, depending upon the parameters fixed under the Air Act and the Water Act. So that is how the legislation was, in fact, taking shape. And the Wildlife Protection Act also legalized the Central Zoo Authority, and it has a zoo authority in every state also now. So therefore, going by all this, these environmental legislations were happening, and in the meantime, a very big tragedy came to us. It fell upon us in the shape of the Bhopal gas tragedy, as you all know. And subsequently, a year thereafter, the Serum gas leak case of Delhi. Both were a very big national disaster on the environmental aspects, led to loss of many lives, thousands of lives, and it also affected the general livelihood and the general right to life of a citizen. In as much as we all began to realize that indiscriminate use and exploitation of natural resources and industry would actually and ultimately affect our day-to-day life. It is directly affecting our life, and therefore it had a direct nexus with our existence. During these times, in the first scenario, when the Serum Fertilizer case came, even though the incident happened after the Bhopal gas tragedy, but the judgment in the Serum Fertilizer case came before the Bhopal gas tragedy case judgment. The Serum Fertilizer case was the first case in which the rule of strict liability, as we all know in tortious liability, about in the Rylands versus Fletcher judgment, the celebrated case, the courts thought it fit to devise a new strategy and gave a new phrase to the strict liability doctrine by saying that it is an absolute liability. That absolute liability principle was given in the Serum Fertilizer gas leak case, which was later on converted into a polluter's pay principle in subsequent judgments, meaning thereby that it is an absolute liability, a person or an industry, even if it is not at fault for any gas leak or any hazardous activities, or if something happens and the society is affected, then the doctrine of absolute liability was evolved to mark a clear departure from the reliance on the traditional law of strict liability. And the occupier pays principle was devised that even if there is no fault of the industrial owner, but he has to pay and he has to compensate for the damages caused. The aftermath of the Bhopal gas leak tragedy was perhaps the most consequential trigger for the evolution of the environmental jurisprudence in India. There was a lot of hue and cry, and there was international issues also involved in that, international laws also involved. Bhopal gas leak disaster, Processing of Claims Act 1985 was also enacted to empower the state to file for compensation on behalf of a citizen. Because Bhopal gas leak, many people were affected and many of them were destitute, and they were not even aware or able enough to fight with a great multinational giant or to apply for compensation and go through the morals of the court proceedings. For this particular Parliamentary Act of Bhopal Gas Leak Disaster Act 1985 empowered the central government to file cases of compensation on behalf of the common citizen. Therefore, when the absolute liability doctrines were evolved, as we all know, by that time, we also have our Directive Principles of State Policy in 48A. Then we have our fundamental duties under 51A G to protect our environment. And this was also the basic principle of the absolute liability doctrine. I will quote from the Serum gas leak judgment. It says, the court has observed, we are of the view that an enterprise which is engaged in a hazardous or inherently dangerous industry, which poses a potential threat to the health and safety of the persons working in the factory and residing in the surrounding areas, owes an absolute and non-delegable duty to the community to ensure that no harm results to anyone on account of hazardous or inherently dangerous activity which it has undertaken. This was the principle on which the absolute liability principle was evolved. Subsequently, as we all know, came the Boon Valley case, arising from Dehradun Valley, which is popularly known as Boon Valley case of 1985, and which gave the entire environmental jurisprudence and evolution of environmental jurisprudence by Supreme Court, the first thrust by Justice Bhagwati's judgment. As we all know, that the Boon Valley case, Supreme Court evolved the concept of environmental degradation and the rights of a citizen vis-a-vis the environment based upon Article 21 and bringing Article 21 in coherence with the Directive Principles of State Policy, and also said that Directive Principles of State Policy at times can be enforced, even if it is held to be non-enforceable, by bringing in Article 14 and Article 21 of the Constitution. Therefore, the right to life was brought in to evolve the environmental jurisprudence. Then came the Faridabad mining case of 2013, which also accepted the Boon Valley case judgment. In Boon Valley judgment, as we all know, Justice Bhagwati largely depended upon a committee's report where the indiscriminate use of quarry mining in that Uttarakhand area of Boon Valley had resulted in environmental degradation. But Justice Bhagwati, in the judgment of Boon Valley case, evolved his own principles, relied upon the report of the committee, but he gave principles and involved his own theories brought in Article 21, Article 48A, 51G, and very eloquently dealt with environmental jurisprudence to say that there has to be a balance. There cannot be an indiscriminate use of natural resources and exploitation at the cost of the environment and at the cost of the citizen living around the environment. They also have a right to life, and every person has a right to a free, unpolluted air, unpolluted water, and an ecological balance has to be maintained. That principle was evolved by largely basing upon Article 21 of the Constitution of India, by bringing right to life as a primary right to life of a healthy environment. That takes care, and this also shows that our Constitution has enough safeguards, enough doctrines and principles which can independently give rise to environmental jurisprudence without bringing in any foreign principle or doctrine to protect our environment. So that is the first principle in the Boon Valley case that we come across. Then, as we all know, over a period of time, it has evolved that the Vasudev Yadav case of state of Bihar, where sawmill industries were regulated, the mining cases. Then finally, the establishment of the National Green Tribunal was by far the greatest contribution of the Indian judiciary. The trigger for the establishment of National Green Tribunal was not a legislative trigger, a legislative will. It was through the trigger of the different judicial pronouncements, right from Boon Valley case to the different mining cases and other cases judgments. The Serum gas leak case was the first case which had given a hint that a special tribunal is required for deciding such environmental degradation cases. Then it consequently gave right to the Council for Environmental Legal Action 1996, and Andhra Pradesh Pollution Control Board case of 1999. All of them gave trigger and in fact pushed the legislative will to come out with a legislation that we now very popularly known as National Green Tribunal. The National Green Tribunal by now have assumed a very prominent place in our environmental jurisprudence. Every state, every region has now a Green Tribunal, East, West, and South, and our National Green Tribunal at New Delhi. And the appeal lies directly to the Supreme Court from the orders passed by it. And this also consists of a judicial member as well as expert bodies, expert members from different fields, who can understand the environmental aspects of any problem which crops up and which is brought before them. And they can understand it in a better way, and they can legally devise an order to give impetus to the environmental protection. Now, therefore, the National Green Tribunals have taken upon themselves the role of a watch body on the environmental issues. And it is our judiciary which has given the trigger for the establishment of such a Green Tribunal. We can, while discussing about the environmental sciences and the constitutional repose and the judicial interpretations, we can never forget the contribution of Justice Kuldeep Singh of the Supreme Court of India, who is now popularly known as a Green Judge, and who was responsible for continuing mandamus matters in different cases, like in Taj Corridor case, and who gave for the first time the doctrine of the public trust doctrine, that the state is the trustee of all natural resources. Nobody can have a private ownership of the natural resources. This principle he involved through various decisions, like in MC Mehta versus Kamal Nath judgment, where he termed river bias. When Span Resort was coming up and they were trying to, in a Kulu Manali highway, they were trying to overcome the flow of the river by diverting it something. Then he gave the doctrine of he called river bias as young and dynamic. A kind of a concept given to a river as a young and dynamic person, which now later on has formally formalized in the Uttarakhand judgment, as rivers now have been recognized as a juristic person. Here also, the public trust doctrine was given, and he heavily relied upon the Article 21, and the polluter pay principle was evolved by him, that whosoever damages the environment has to pay, whether he is responsible or not. But we must be aware of the consequences of his activities in the industry. If it results into depredation and degradation, then he has to pay and he has to compensate suitably. The polluter pay principle is also enshrined in Section 20 of the National Green Tribunals Act also. Then Justice Kuldeep Singh also involved the precautionary principle and sustainable development principle. In the Vellore citizen case, he developed the precautionary principle that sustainable development is all right, but there has to be a precautionary principle. We have to be precaution. We have to understand the implications of any industry or activity which can go on. So development is all right, but it has to be a sustainable development. If the development is such that it can irreversibly complicate things that the nature has given to us, is not acceptable. So that is a precaution that we have to adopt. And therefore he had developed a fine, therefore he said that there has to be a fine balance in heart and the head. So we have to think about the head and the heart both at the same time, while evolving any philosophy or any policy or jurisprudence on the environment. Then we all know that he was largely responsible for the Taj Corridor, where he was instrumental in relocating all the industries and tanneries and brick kilns around Taj Mahal and shifted it to adjoining areas. Also at the same time, ensuring that the workmen who were employed in those brick kilns were not displaced by giving directions that they should be suitably employed, and the employer should, in the meantime, when he gave a buffer time of shifting of 3 months, during that 3 months period, they will have to be paid full salary. That is how we ensured that the livelihood is also not lost, and the brick kilns and other industries which were affecting the Taj Mahal were also shifted accordingly. Then we all know that he has given so many other judgments on the issue of mandatory environment clearances, that in the shrimp farming matter of Odisha, as we all know, was a very celebrated and very well-known case where with the environmental impact of shrimp farming, he gave a principle that environmental clearance is a sine qua non for all shrimp farming industries. That became a trigger for environmental clearances for all industrial purposes. Thereafter, any project, even a building is to be constructed, it has to undergo an environmental impact assessment and environmental clearance. That was the impact of his judgments, and he was a very passionate judge, and we all owe a lot of environmental jurisprudence to him. Then the first jurisprudence, as we all know, of Doon Valley case, where Justice P.N. Bhagwati had dealt with the law of environmental protection with respect to Article 21. And then the guiding light was the Sachidanand Pandey judgment arising from a West Bengal case, where an area which was earmarked for Jew was to be allocated for constructing a 5-star hotel. That judgment was rendered by, as we all know, philosopher Judge Justice O. Chinnappa Reddy. He gave a thrust to the directive principles of the state policy. This was the first when he said, when the court is called upon to give effect to the directive principle and the fundamental duty, the court is not to shrug its shoulders and say the priorities are a matter of policy and so it is a matter for the policy making authority. Therefore, the courts will not shrug it off, and it will certainly step in by incorporating Article 21 and Article 14 to give thrust to the policy making as well as to give a special directions for the protection of the environment. And he for the first time coined the words, I consider my rivers to be my sisters, flowers to be my sisters, and the animals which live there moving in the jungle to be my brother, because they are all a part of the entire environment. It is the earth which has given this every day to us. This principle that rivers are my sisters, animals are my brothers, environment is the same. We are also a part of that environment and forest. This principle has now come down in 2017, the recent Uttarakhand High Court judgment, in the Muhammad Salim case, where the court says that the Ganga and Yamuna have juristic entity. They do not have legs and hands or even heart to tell us, or any voice to tell us that they have been affected, violated. But they are a juristic person, and therefore they have to be given. They have certain rights. Therefore, River Ganga and River Yamuna have certain rights which requires protection, and therefore direction can be issued for their safety under Article 21 of the Constitution. So that is a very novel concept, which still requires a lot of elaborations at the Supreme Court level. Tomorrow we will have another good judgment on that aspect. But this is a very novel concept where we ourselves recognize River Ganga as River Mata. We have to the status of a goddess. That is the same principle as we all know that our civilizational ethos, we have to fall back upon those our civilizational ethos to respect our environment, to respect our rivers, mountains, forests, and our natural resources. Because they are a part of us, we are a part of them. And then to recognize those rights, the Forest Act, Forest People Act, that is called FRA Act, Forest Rights Act, which is popularly called, which came in 2006. It gave forest rights to the people living in the forest. And it also empowered them that no developmental activities around forest or inside the forest can be done without their consent. So the forest rights of individuals or the tribes or the groups residing within the forest area or around the forest area was recognized. They were given the right of livelihood and interdependence. And also the concept of intergenerational equity also came. This was a very broad concept about the environmental laws, that what we have today is or has been given by our forefathers, and we have to protect it, to give it to our children in the next generation. That is for intergenerational equity. We don't have the right of absolute exploitation of the resources that we have today. We have got it from our forefathers, and we have to keep it and preserve it as a public trust doctrine to pass it on to our next generation. That principle was evolved, and that is how it is evolving, and that is the best concept of our constitutional ethos, to be in harmony and be synchronized with the environmental sciences. And because I am time and again harping upon our civilization ethos, our broad-based society, Sanatan Dharma, which has a great respect for environment and the forests and the mountains and the rivers. Because the mindset of the people and their involvement and assimilation with the nature is a primary purpose and aspect by which we can preserve our environment. We can't preserve our environment merely by enacting a law. Until unless it is there in our society, in our mindset, in our civilization, we cannot give protection to the environment until unless we realize that we are a part of it, and they have the status of a demigod and goddesses, and therefore we have to respect them and personify them as a god and goddesses, and by giving them respect, then only we can save them. Otherwise, if we just in a paper book manner, we cannot preserve our environment, or we cannot bring in only environmental sciences to understand the law of nature. Then, as you know, I have done my graduation from Delhi University as well as law from Delhi University. I can tell you my difficulties in boarding a Delhi Transport Corporation bus. Was so populated, so overloaded, and everything. It was very difficult. And those days, when we used to stand on a bus stop in Delhi, our eyes used to burn because of the pollution level there at that point of time. In early 90s, I am speaking about late 80s and early 90s. Supreme Court turned it aside, in fact, gave a very cleaner air to Delhi, almost in a very, iron-handed manner in that, Delhi bus fleet case, where it compelled the government, and they brought in GAIL, made it a party, gave directions, slew of directions, and continuing mandamus theory, and CNG, compressed natural gas, was evolved, and it was replaced by petrol and diesel. So all buses of DTC thereafter began to be run on CNG, and that drastically improved the air quality of Delhi. I can tell you about that. That is a great contribution of Supreme Court in the Delhi bus fleet case by bringing in CNG in place of petrol and diesel. Then we all know that T.N. Godavarman case. It is a continuing mandamus. It is still going on. Time and again, petitions can be filed in that T.N. Godavarman matter. It is taken up by the Supreme Court. A slew of directions have been given in T.N. Godavarman, and it is largely responsible for protection of our forest. Sawmills, it has also restricted the upcoming of new sawmills in the area, which were largely responsible for tree felling and cutting of the trees in and around forest area. And T.N. Godavarman, when the judgments came during late 90s, it evolved the philosophy of 1/3 and 2/3, that at least 1/3 should be the forest, 2/3 should be the plains. In the mountain area, it is 2/3, 1/3. But then, after the T.N. Godavarman judgment began to monitor the environmental issues in the country and the forest particularly, the percentage of forest in country increased from 17% at that time in 1996 to more than 22% overall general ratio. In Jharkhand, we have 30% forest cover. It's a very good cover. It used to be 28% around 10 years ago. Now it has increased to 30%. So the forest cover actually has increased in Jharkhand and other areas also. So this pro-environmental continuing mandamus philosophy of the Supreme Court in T.N. Godavarman has greatly answered many of the environmental issues, and by giving a policy thrust by way of the court's directions. So for the first, the post T.N. Godavarman, we can largely divide the environmental judgments and the decisions into, first is a shift from pro-development to pro-environment. Second is the acknowledgement of the right of the local people to shape their environment, which resulted into the Forest Rights Act of 2006. And lastly, the change in the approach of the court from a passive onlooker to an active strategist in environmental cases by giving important directions for actually doing something for the environment rather than just passing delivering a judgment on the issue. That is the impact of T.N. Godavarman given now. And there are important judgments, as we all know, of nature lovers movement versus state of Kerala in 2009, which gave a first judgment on the issue of that non-forest use can be done of any forest activity of any inside any forest area without the prior approval of the central government. Then the dyeing factory tanneries case, then the Nambiar case of Karnataka, where even in a dense forest plantation of was formulated, plantation strategy was formulated by the state government. The courts interjected and they stopped it, saying that no, in a forest area you cannot do a non-forest activity, even if it relates to a plantation. So a forest has to grow as a natural cover, and we have to understand the philosophy of a forest, that it is a self-generating area and it is a self-sustainable area, and the livelihood of many of the persons, tribes, groups, forest groups are dependent upon, they are very symbiotic relationship with that. And thereafter, the Goa mining case, as you all know, in iron ore mines were very much regulated by the Goa Foundation matter, and the Odisha Mining Corporation case, where also the iron ore mining and coal mining in Goa and in Odisha was regulated. The indiscriminate use was stopped by the Supreme Court, and it has given a very, it has come down to a level where different laws and different notifications were issued under the Environmental Protection Act. And now we have environmental impact assessment given for an ongoing project. It has also now to incur environmental impact assessment, and it has to pay for the it has to compensate the society for the damages caused by its industry, by its activities. So therefore, there has to be a harmonious balance. At the same time, we have also to draw a line where in the name of our development or any pro-development activities, we cannot allow any or every kind of forest degradation. Like we have in Jharkhand, there are go areas and no-go areas. Jharkhand has in the Saranda forest massive iron ore deposits, but it is also the best natural forest area available, cover area for the entire country. So the central government has given certain go areas and no-go areas in the forest. But even if there is enormous iron ore deposit in a no-go area, you cannot undertake iron ore activities or mining activities in a no-go area. In a Saranda area particularly, it's a very well dense and it's a tropical forest in that region. So therefore, in the name of a development or mining activity or in the name of exploitation of natural resources, we cannot irreversibly damage our forest cover and our environment. So this is how we have evolved over the years, and we are still in the process of evolution. where the judgments and the court's interventions are there in the policy making, as well as the Environmental Protection Act gives ample power to the central government also to evolve different policies, guidelines. And environmental impact assessment is now largely the grand norm for all the environmental projects, all the industrial activities may go on throughout the country, that without an environmental impact assessment or without environmental clearance, no activity can be undertaken or can proceed. And those which are already operational have to have a every year consent to operate renewal to be taken from the pollution control boards, without which the activities cannot go on. And now we have expert body, experts which can take care of the environmental sciences, because environment now is more of a science. It's highly technical in nature. Therefore, we have to understand the impact of an industry with an environment and its depredation and degradation, whatever. There has to be a synchronous activities and the understanding of the situations. Therefore, we in the National Green Tribunal also now we have expert bodies, experts also there who have to decide, who can undertake the research studies also and direct for. There are different national bodies in Dehradun and in other places in Hyderabad, which are largely research bodies on environment. And the National Green Tribunals have been taking help of their research papers also while giving and delivering judgments. So now we are all in safe hands of National Green Tribunal, and the Supreme Court is taking care that they are functional and they have all the facilities. And lawyers also are making merry. The number of good cases and big and different diverse cases are coming up before the NGT, and they are having a field day, earning a lot. At the same time, protecting the environment also in some way. So lawyers also have a great role to play in this evolution of environmental law and environmental jurisprudence. So that is all my understanding of the environmental sciences and the interplay with the Constitution and the constitutional loopholes. And I thank you all for giving me this opportunity to delve upon this very relevant and important topic of the day. And thank you very much, Dr. Bendale. Thank you again.
Thank you very much, sir.
Thank you so much, sir. Thank you so much.
Thank you very much, sir, for such an amazing exposition, adequately mapping the interplay between constitutional law and environmental sciences. I am confident with the epistemological touch in your good self speech, peppered with own experiences, every student of law would have well understood the various dynamics and depths associated with environmental jurisprudence. Sir, we are equally happy to inform your good selves that the environmental cell has been instrumental in ensuring that electric buses ply on the roads of Pune, which have substantially improved the air quality index of the city. Sir, as your good selves know that we, with this webinar is being live streamed and is being beaming live across our platforms, we have received some questions. If your good selves would permit for the same.
Let me see if I'm able to answer any of them.
So I'm sure that a precise and a clear answer would be received. Sir, the first question is, what role have PIL played in developing environmental jurisprudence?
PIL has played a very important role. As you know, the Doon Valley case also arose out of a PIL, public interest litigation. Like, you see a lot of cases where MC Mehta versus Union of India is the leading judgment. Even Tian Godavarman case was a PIL. And on a later, Justice Bhagwati had evolved the entire doctrine of public interest litigation in this Doon Valley case in 1985. So public interest litigation has come up, it has played a very important and a big role in evolution of environmental jurisprudence in our country. And even now it goes on and on, it continues in that direction.
Absolutely, sir. So the next question is, most of the NGTs today are having no bench, having no strength on their bench. In this regard, what role can NGT play in ensuring that environmental justice prevails?
Yes, you are correct. This was true for a quite number of years because during the last couple of years, the pre-corona stage on during corona period, the NGTs, the members, judicial members had retired, and the technical members also had retired. That their tenureship had ended. But now Supreme Court is in session of the matter. It is in a case in the Madras Bar Association case. It is monitoring the recruitment process and functionality of the tribunals, including the National Green Tribunal. And because of its various directions, recently the posts have been filled up, and many of the regional centers which were not functional, like Eastern Zone NGT, not functional in Calcutta, has become functional now. So now Supreme Court is monitoring that the tribunals should be adequately staffed and the members should be appointed without any delay so that they remain functional.
Thank you, sir. Thank you very much. We are flooded with questions, but I guess with paucity of time, we will be ensuring that a favorable answer will be given to all those questions. With this, we now move to the vote of thanks. It is to my honors that I have got this opportunity to present the vote of thanks for today's event. At the outset, we would like to fondly remember our founder chancellor, Dr. Patangrao Kadam sir, because of whose blessings this event has been a great success. We are grateful to our esteemed guest, Senior Advocate Shri Rajiv Ranjan sir, who took out time from his busy schedule and graced this occasion. We express our sincere gratitude to Honorable Advocate Rajendra Umap sir, Vice Chairman of Bar Council of Maharashtra and Goa, for gracing this occasion with his esteemed presence. A special mention of the unwavering support provided to us by our visionary and dynamic principal, Dr. Ujjwala Pendale ma'am, Dean and In-Charge Principal of Bharati Vidyapeeth Deemed University New Law College, Pune. Also, nothing seems to be complete without acknowledging the efforts by Dr. Jyoti Dharma Madam, Head of the Environment Cell, and Dr. Jayashree Khandare Madam, Coordinator of the Environment Cell, Bharati Vidyapeeth, Deemed to be University New Law College, Pune, who have made the Environment Cell what it is today and have equally ensured that the spirit of environmental conservation is well percolated in the hearts and minds of all the students. Lastly, we thank all our volunteers, our non-teaching staffs, members of our technical team, because of whom we could connect through this digital space. Finally, we thank all of you for joining us and in this event and making this a success. Lastly, we once again say from the bottom of our hearts, thank you.
Thank you.
May I now request
all of you.
Thank you. So may I now request everybody to switch on their cameras for a good photo, please. Thank you, sir. Thank you, sir.
Yes, sir. Thank you, sir. Thank you
Thank
so
you.
much.
Thank you.
Thank you, sir.
So thank you so much.
Thank
It was
you.
indeed a very enlightening session, and we went through all the provisions of Constitution and all the cases right from the beginning. Thank you so much, sir.
True,
Dr.
true, very
Ujjwala.
true, ma'am.
Thank you so much.
Thank you.
My pleasure.